initiated by IBBI against IPs. If you go through that IBBI website, the various orders, the disciplinary committee, DC means disciplinary committee. So many orders are there. Because even though everybody knows about the rules, everybody knows about the regulation, everybody knows about judicial pronouncement, everybody knows about the code, still during the assignment, they are knowingly or unknowingly or intentionally or unintentionally, they are doing some mistakes. So thereby, IBBI is also punishing them. The disciplinary committee of IBBI, they are punishing them. They are cancelling the license or whatever the certificate authorized for assignment. In addition to that, they are also they imposing some penalties, etc., etc. So we should be cautious. We are in the profession. We have to follow the code. The code or regulations are issued by IBBI or updated by the IBBI from time to time. Once that clear-cut instructions are there and we are the matured person and after 10 years of the profession like a CA or CMA or a CS or the legal advocates or 15 years of work experience in the managerial capacity and after the tough examination of LIE exam, during that LIE exam also everybody is referring that rules, regulations, judicial pronouncement and relevant acts and code, still why they are doing mistakes? Why they are inviting punishments? So that's why this area also we want to continue in the profession. Daily we have to read whatever the DC orders are there. Max to max 3 to 4 per month is happening. So the 3 to 4 orders are also available in the IBBI website. And go through that order. What mistakes are, what errors are, what the violation of the regulations, rules, the RPs or liquidators they are doing. So today's class is the disciplinary action initiated by IBBI, and tomorrow, what are the frequent errors that are committed by the particular RPs or liquidators, etc., etc. Practitioner learning in insolvency practice. Sir, this is not a one-time measure. Once LIE examination is over, then we have passed that examination. Then I need not update the particular updations, means that is not correct. The role of the resolution professor under IBC is a highly dynamic. It is ever changing. Even the recently also, some amendments are there and requiring not only the statutory compliance, but also sound judgment. And ethical conduct is also very much required. And the procedural, the precision is also required. If at all the precision and the accuracy is not there, then it will be a problem. It will be a problem. So that's why all are that is to be followed by the IPs from time to time. So the precision, the accuracy or precision or sound judgment or ethical conduct, all these things are required. In this evolving legal and regulatory environment, regularly reading the cases finalized by the DC Disciplinary Committee of IBBI become essential for improving the quality of my assignment, that is CARP or liquidation or PPIRP or personal guarantor to corporate debtor or the voluntary all these things. Quality to be improved means what type of mistakes commonly they are doing, what type of irregularities they are doing. It is to be continuously updated the norms. Then only the quality will increase. Then only the quality will increase. So the quality to be maintained by the artists, that is very much required in the insolvency profession. 1 minute, some sound is coming, sir.
Some voice is coming. Background noise.
Dushyant Kumar, but the mic is 1 minute. I am rectifying that one, but it is not allowing me. Okay, sir. So, in this evolving legal and regulatory environment, regularly reading the cases are finalized by the disciplinary committee of IBBI become essential. That is compulsory. These cases published in IBBI website and through insolvency professional agencies, IPAs, serve as a practical lessons drawn from real life of failures, lapses, and misconduct of the professions. That's why law and practice. Law and practice. Insolvency, law and practice. One professional course is also one professional subject is also there in the final examination of ICSI also. So, law and practice. Sometimes the practice may be differ the law, but with intention and all these things are there, then automatically it invites criticism and punishments. Disciplinary committee orders clearly outline what is expected from Sir, Dushyant Kumar sir, you put it on mute, sir, from your side. Dushyant Kumar sir, put it on mute. So the disciplinary committee orders a outline what is expected from RP in the conduct of a CIRP and a liquidation. They will also tell about all these things. The disciplinary committee, what he has done and what is to be done and why the negligence, all these things they are giving in a sequence manner. What mistakes are, what errors are, how he bypassed the regulations and all these things they are mentioning in that orders.
Another 1 minute, sir. Similar. The questions are already counted. ಹತ್ತು ಬಂದಿದೆ ಅಕೌಂಟ್
ಎಷ್ಟಿದೆ ಎಷ್ಟು ಬರಬೇಕು
ಇದ್ರದ್ದೊಂದು 10 ಬಂತು ಅಂದ್ರೆ 20 ಆಗ್ಬಿಡುತ್ತೆ. ಇನ್ನೊಂದು 60 ಬೇಕಾಗಿರೋದು ಇನ್ನ 40 ಮಾಡಬೇಕು. ಟೋಟಲ್ 60 ಬೇಕಾಗಿರೋದು ಇನ್ನ 40 ಮಾಡಬೇಕು
ಸರ್. ದುಷ್ಯಂತ್ ಕುಮಾರ್
ಅಟ್ಲೈತೆ ಇನ್ನು 20 ಮಾಡಬೇಕು.
ಕಂಡೀಷನ್ ಸರ್,
ಇಯರ್ ಡಿಸೆಂಬರ್ ವರೆಗೂ ಟೈಮ್ ಇದೆ ನಮಗೆ.
అవునా ఎవ్రీ ఇయర్
ఇంక్రీజ్ అవుతుందంట.
ఎవ్రీ ఇయర్ 10 ఇంక్రీజ్ అవుతుందా? అలాంటప్పుడు ఆఫ్టర్ 10 years it become
Sir, you can ask ICSI team.
1 minute.
ಸರ್ 28 ವರೆಗೂ ಅವ್ನು ಇನ್ಕ್ರೀಸ್ ಮಾಡ್ತಾನೆ ಅನ್ಸುತ್ತೆ. ಅದಾದ್ಮೇಲೆ ಬೇಕಂದ್ರೆ ಮತ್ತೆ ಬೇಸಿಕ್ ಇಂದ ಬರ್ತಾನೆ.
Can you please put it on mute, Mr. Dushyant Kumar? Lot of noise is coming. Can you please put yourself on mute?
ಆಯ್ತು ಮೇಡಮ್ ನಿಮ್ದು
I think he is not listening, I think.
ಹಚ್ಚಿರಲ್ಲಿದ್ದೀರಾ
1 minute. I am contacting that madam, sir. Madam, here K. Dushyanta Kumar, he is talking. That's why it is a disturbance to others also. Or you give me the powers to me. I will put it on mute.
ಆಮೇಲೆ ಲಂಚ ಇಲ್ಲ ಸತ್ತನೇ ಇತ್ತು ನಮಗೆ ಆ್ಯಕ್ಚುಲಿ ಇದನ್ನು ಅಷ್ಟೇ ಪಲಾವಲು ಎರಡರಲ್ಲಿ ಕಡಿಮೆ ಇತ್ತು
No better.
No, 1 minute. Not Dushyanta Kumar. Mute all. Now my voice is audible, sir. Now.
Yes, sir. Yes.
Okay.
Yes, sir.
Okay.
Very clear.
Now because the disturbance, because my thoughts are not properly given, it in a queue, it is not happening. That's why I requested them. Will the code, the rules and regulation provide a legal framework? Disciplinary committee orders interpret these provisions in practical scenarios also. For that purpose only the regulations are issued. The main object of the regulation, what is the purpose of regulation? It is operational instructions. The code is not useful in practical scenario. The practical scenario that how to implement the IBC code is through regulations and rules only. If that regulations and rules and code is not properly adopted, then the purpose will be defeated. The purpose will be defeated. By studying these cases, whatever the disciplinary committee cases are there, RP gain clarity on how regulators view compliance, due diligence, independence, and transparency and fairness in decision making. So the quality of the CIRP or liquidation or other products, once you along with the code, rules, regulation and judicial precedents, you should also read the disciplinary committee findings with regard to various cases. Learning from mistakes of others. So if at all they are doing mistakes, then automatically whenever I am handling the particular assignments, definitely it is lingering in my mind. Okay, that on account of the bypass or the mistake, the punishment will happen, or they will cancel the certificate, or some amount they will impose. One of the most important benefits of reading disciplinary committee cases is the opportunity to learn from the mistakes committed by the other professions. These cases are highly common errors, failure to maintain proper records. Once it is not maintained, how he will move forward? And if at all the adjudicating authority or the committee of creditors or the financial creditors or operational creditors, if at all they are asking something, if you are not maintaining, how to retrieve the information? Retrieval of information is also very, very important. So today, once your claims are admitted, and later on some doubts are arised, why you have classified the operational creditor into financial creditor? If that papers are not available, how you will communicate? Non-adherence of the time limits. 6 months is the best time, to my knowledge is concerned. 180 days means 6 months. Another 90 days, the leverage or cushion is also there. So what is the problem? If at all you are dumped with various activities, then concentration will lack and a timely adherence of the schedule. So the day one, you have to prepare the checklist up to the form H to be filed. Up to form H. What are the activities to be done? Day wise, day wise, day wise. Once one activity is completed, in my mind, what is the next activity? What is the next activity? What is the next activity? If at all I am thinking in such a manner, definitely the quality will increase. This is not a rocket science. The planning, the time management is very much required. This is a project. CIRP is a event management, liquidation also event management, PPIRP also event management, voluntary liquidation is also event management, and personal guarantor to corporate data also event management. The events are defined in the regulation. Once I have completed each and every event, I have to move to the next event. Thereby, lot of comfort will be there. So, non-adherence of the timelines, what is the problem to adhere the timelines? And after a thorough examination, after some research, they have finalized the timelines. Within the timelines, that is the standards. Once I am defining the standard, I am not exactly defined. I will add 20% or 30% additional time also. So that a common professional, they on a good professional also, they can handle that assignment within the time. Conflict of interest issue. Independence, independence, independence. Why we are they particularly the related party transactions, all these things are there. Why you are giving favor to some people in the particular process? Once independence is one of the important area, improper conduct of the COC meeting. Once you are inviting for COC meeting, you should be updated the knowledge. What is the agenda? What are the papers to be carried? What are the probable questions that are going to rise in the COC meeting? What is the pending issues? All these things, the time management and planning is also very much required for the professions. And mishandling of a liquidation of asset. You are the CEO. You are the trustee of the assets of the corporate debtor. Why you are leaving like that? Suppose some big asset is there. Appoint security. Today, outsourcing security agencies are there. Which are the best agency you find out from your colleagues and take their services to safeguard the asset. And if at all you are leaving like that, if at all that is your property, are you leaving? No. So the property, whether it is a stock or whether it is a plant and machinery or whether it is office premises or computers, furniture, whatever it is there, it is your baby, not the corporate debtor baby. He is out from that particular premises. So mishandling of the liquidation of assets. And okay, some other company, the liquidators, as per their wish, they are selling that. In that case, what is the purpose of value maximization? Next, by understanding these pitfalls, RB can proactively avoid repeating similar mistakes. So your skills will be enlarged. Your quality of the CIRP or liquidation will enhance once you are reading the DC committee orders. Only 2 or 3 pages. That too monthly 2 are there. Hardly it will take 1 hour for you. But indirect effect is a lot of indirect benefits are there to you. By understanding these pitfalls, RP can proactively avoiding similar mistakes in their own assignment, thereby safeguarding the professional reputation and the registration. Once I'm doing wrong things and my license is cancelled, then it is a reputation risk. Or 2 years you are not eligible to do the particular practice. That is also the image risk. And all are publicly the document. Even all RP names are available in the IBBI to everybody. So the professional reputation. Suppose you are frequently interacting with the particular financial creditor for additional cases. Once this type of things are happening, forever, they will not give any cases. So that is a lost case. So that's why to improve the reputation, to increase the image of the profession, definitely we have to follow the guidelines. Enhancing the professional judgment and decision making. Many disciplinary cases involve a situation where RP has exercised discretion. The DC examination, whether the discretion exercised judicially or not. Okay, in the case of liquidation or amount spent, the CIRP cost, discretion is there. Suppose the employees are available within the company. Why you are hiring the outside? We have to minimize the CIRP cost to a large extent. Because thereby the others will be benefited. Even in the liquidation also, try maximum to sell the asset with a good amount, not the lower amount. It is your asset. It is your asset. You are the trustee for that assets. So enhancing the professional judgment and decision making. Reading this order helps RP to understand boundaries of their authority. So the Lakshmana Rekha. So we should not cross these boundaries. If at all I crossed, IBBI will penalize or DC, disciplinary committee will penalize. When to seek a COC approval? So what are your powers or duties or all are subject to get approval from the COC? Why you are bypassing COC? That is your board of directors. You are the managing director of the company, and the board of directors is of that CIRP company is nothing but COC. How do document decisions properly? Suppose take for example, one operational creditor claim was submitted. 200 rupees claim submitted. Example, small example. I'm not talking about crores of rupees like that, 200. But he has attached a proof for 100 rupees. For another 100, he is not attached the proof. Write it on the claim form itself. So admitted 100 only, not 200 due to non-submission of the proof for the claim. Verify the books of records. Some of the cases verify the books of record. When the books of 100 is there, but whereas he raised the claim for 200. Okay, sometimes the corporate debtor books wrongly prepared. For that purpose only, we are asking the proof of evidence for the claims. Whether it is a bill of exchange or promissory note or invoice or a transport document, etc., etc. So whenever you are taking any decisions, write it on that particular paper, sign it, date and time. Thereby In future, it is very difficult to remember all these things. Why I have admitted to 100 instead of 200? Again, from scratch onwards, I have to verify the books. Means it is a time-taking process. But I have to complete the task within the scheduled time. How to act complex, ambiguous situations? Once you are involved in the CIRP process, once you are fully involved in the liquidation, nothing will happen. Definitely, even tough situations also. First 1 or 2 cases, the problems may be there. After that, it is a cakewalk for you. This improves their ability to take well-informed and defensible decisions in practice. All cases are not equal. All cases are light cases. Some chronic cases also you are going to attach. Once you are following all these things, even the chronic or hard net cases also, it is very easy. Strength, ethical standards and integrity. The insolvency profession demands high ethical standards. If at all I am doing wrong things, or for the money's sake, if at all I did a small wrong thing, that is my profession will be full stop, no comma. Full stop. Later on, no cases. DC orders often deal with the issues lack of independence. Here we are dealing with the money. Whether you are appointing values or whether you are appointing a transactional auditor or a different supporting staff also, independence is required. Take the decision properly without any forces, leave it the forces, bias or misconduct. By studying these cases, RP become more aware of ethical expectations, including maintaining neutrality between the stakeholders, avoiding personal gain, undue influence. Whatever the fees is there, that is sufficient. Suppose take for example, if at all I am yield some money, they are tempted to get some additional money on account of this processes, that is a lost case. Otherwise, if at all I am promptly drawn, number of cases will increase. So, take for example, each case I am getting 10 months. 10 months means I am getting per month 3 lakhs means 30 lakhs. Okay, if a small amount of 5 lakhs additional amount I am tempted means that only 1 case. Otherwise, 10 cases, 10 into 30 lakhs, 3 crores. So this enforces professional integrity and builds trust among the stakeholders. Keeping updated and evolving jurisprudence. IBC is still developing law. That's why recently amendment, why they have done by amendment, some the comfort level to be increased. Regulatory interpretations evolve over time. The IBC is evolving not by the taking by the IBBI or Government of India. Through the judicial pronouncement, either NCLT or NCLAT or so Honorable Supreme Court of India, it is evolving. And disciplinary orders act as a supplementary source of jurisprudence, complementing judicial pronouncement of NCLT or NCLT and the Supreme Court. Regular reading ensures RP stay updated with this. You will become the number 1. This is not a big or rocket science. This is max to max 256 sections and rules, regulations, and that's all, nothing else. Only one area. If at all the account turned into bad or not repaid by the corporate debtor to the financial creditor, the system is evolved. One system is evolved, that is the IBC system. The latest interpretation of the regulations, emerging compliance standards, and a changing expectation of the regulators. Even today, whenever I am going to the NCLT, Honorable the judge, this is a small case. Why you have taken 6 months? Nothing is there. And it is not a going concern. And still, why you are asking another 3 months to get the professional fees? You are asking the 3 months. If at all you are doing like this, I will inform to IBBI. Like that in the court hall, the honorable judge also telling like this in the presence of all some RPs. If that comments are raised by the honorable judges, then it is not good. It is not good. So the continuous learning is a crucial one in fast changing insolvency. This is not a big subject. This is a small subject. Only one code contains 256 sections like that. And CIRP, only one regulation, the master directors, like Reserve Bank of India issue master directors, from time to time, whenever amendments are happening, the IBBI is good enough to give the latest displayed in the IBBI website. And whenever the changes are there, at the bottom of the particular regulation, when it was changed, all are there. Rules are also there. For each and every product, regulation is there. If at all you want to know about the judicial pronouncement, IPS are publishing, IBBI is publishing a quarterly journal, etc., etc. Risk mitigation and professional safeguard. Non-compliance or negligence lead to serious consequences. Kuch nahi hota. Some people, they don't bother. Earlier, I'm giving lecture. One professional asked, sir, I am an expert in this law, sir. I don't want to manage the company and I am not interacting with the workmen and I am not interacting with the production. Sir, that is inbuilt in the system. I am not devised. So, you should be all-rounder. Why they have given the designation like CEO for temporary period of 180 or 270 days? Because you have to run the company, you have to handle the company, whatever with the help of your board of directors, none other than CEOs. By studying the DC cases, RP can identify the risk in advance and implement the safeguards like that. Sir, if a staff shortage, sir, whatever the timelines schedule is given, that is upper limits. It doesn't mean you have to complete on that particular day only. Once one activity is there, go for next activity. Go for next activity. Go for next activity. Some people, on account of remuneration, all these things, why should I complete within 6 months? The mindsets are like that. In the meantime, some errors are happening. Complete this one, throw it out and take next one. By studying the DC cases, RP can identify the risk areas in advance and implement the safeguards like a robust document system. Sir, this is not a big bandar books only. From the day one onwards, whatever the papers you are signing, whatever the papers you are referring, all are to be filed, box filed with the date, flaps, date-wise flaps. Some of them are yellow color, some of them are green color, some of them are red color for reference, because this is a high risk area, this is a medium low risk flaps. Thereafter, retrieval is very, very easy. So the robust documentation is required. All documents in your personal the storage only. Timely filing the reporting. The timely filing. Once one activity is there, if at all any the regulation is there to file with IBBI, immediately on the next moment, that's why you have to prepare the checklist. Once day one, once you received this one, this is a public announcement. After that, formation of Siva, after that, the valuation, after that, the expression of interest, after that, or puff transactions, the finalization of that person, the transactional auditor, after all these things, only one checklist is sufficient. It covers all area, all company, whatever CIRP, n number of CIRP, the same checklist will continue. Proper stakeholders communication. If at all they are in dark, complaints will aggravate. So RP is not updating the information. They will approach to the NCLT or NCLATs. They are not giving any information. They are not updating. What is the problem? You need not speak. Emails are there. WhatsApp is also there. Once it is true, what is the problem? Some people fear psychosis is there. If at all I informed something happens, they will book me also. No. Once you are doing perfect, nobody will object. Adherence of the procedural discipline. This procedure, after that procedure, this reduces the risk of a disciplinary action. Thereby, the disciplinary action will be reduced. Improving the quality of the CIRP and liquidation process. Ultimately, the objective of the IBC is a value maximization and a timely resolution also. Timely resolution also. Ultimately, the object of the IBC is a value maximization and timely resolution. When RP learns from the disciplinary committee cases, they improved their conduct of efficiency in handling the case. That's why it is better to read the orders that are uploaded in the IBBI website. Hardly it will take 1 hour per month. This leads to better management of the corporate data assets, transparent and fairness processes happening, higher confidence among the creditors and investors, and improve the outcome of the resolution and the resolution. Confidence among, once that person, sir, that RP, excellent RP, sir, whatever information they are passing to us, and there, if at all our issues are there, immediately he is resolving, sir. That's why number of cases is always a danger. Some people are out of hungry of cases, they will manage it. That's why the restrictions are also placed by the IBBI. Earlier, I'm handling 20 cases, 30 cases. If at all you are not giving adequate attention or time to each and every case, what is the purpose of 20 cases? That hungry is not required. Profession quality will deteriorate. Professional development and capacity building. Regular engagement with the disciplinary cases contribute to overall professional development of RPs. It sharpens the analytical skills. Once you are following this one, you will become the advisor also. You will become the consultants or consultancy services also, in addition to handling of a CIRP, particularly with regard to IB. Some critical decisions, if at all they are asking, You offer your comments and take a suitable remuneration. Once I am a perfect in regulation, perfect in code, perfect in judicial pronouncements, and perfect in reading that particular disciplinary committee cases, definitely you can offer the valuable advisory services to the critical cases also. Because the subject is nothing for you. Because daily you are updating the knowledge. It sharpens the analytical skills, enhances the legal understanding, and builds a practical insight. IPS often circulates such cases, training purpose, make them valuable educational tools for both and new and experienced professionals. Sir, learning is a continuous process. I'm the experienced person. I know A to Z means that is not correct. Learning process is a continuous process. Even every faculty, we can extract some information. Not 100%, not possible from any faculty. Even 10 or 5% also. If at all it accumulates, cumulative effect is there, definitely it enhances your knowledge. Every faculty. It is a finally, it is a preventive and a corrective tool. Reading disciplinary cases, IBBI is not merely academic exercise. It is not academic, but preventive and corrective mechanisms for the resolution. Whenever I am doing that activity, immediately my mind is thinking that disciplinary committee judgment, then I will be in a cautious manner. And I will be attentive. Then quality, precision will increase. It helps avoiding errors, strengthen the compliance, enhancing the ethical conduct, and improving the professional competency. That is the ultimate goal, professional competency. Once we are identified as a professional, the competency level should be increased. In a profession where even minor lapses can have significant concepts. Significant the consequences. Once I have done, I have taken a operational creditor into financial creditor. Imagine what are the consequences. I am wrongly taken as if, but COC also, even the banks also, their officials are frequently transferring from one branch to another. Today, if at all I am in stress result, tomorrow I may be the handling the regional office, or I may be the administrator, or I may be in HR, like that. So it is also not possible that a COC is 100% correct. You have to guide the COC. You are the friend, philosopher, whatever the words you are going to use. In a profession where minor lapses have significant consequences, staying informed through the cases is not optional. It is essential responsibility of every. It is small errors. No. Small errors, only one small error. At that time, due to precision or whatever this one, I have wrongly classified, then complete voting right changes. And whatever the decisions or resolutions are passed, that is also null and void. So that's why reading the disciplinary cases is a preventive and a corrective tool. That's why you have to read that one. So disciplining the IPs by IBBI. IBBI is a discipline. They are using the stick. They are using the stick whether the IPs are doing correctly or not through disciplinary committee. So this is the screen. So the screen that orders are also available. Go through the orders once in a month end, you put one date, month end, or first of the month, or first week of the month, or second week of the month. Every month on that day, you open and one or two or three cases are there. Go through that one and definitely it will increase. Not only that one, IBC knowledge capsule is also released by ICSI insolvency professionals also. They are also framed for a disciplinary mechanism under IBC. How they are doing some wrong things, what are the penalties, and how many days or amount, all these things through this also. Not only this one, the disciplinary committee orders are like this on 21 March 2025. IBBI DC 277 divided by 2025 order. So narrating is beautifully designed. Easy to understand also because you are a professional. That too, you know about the IBC. It is a cakewalk for you to understand the order also. So that's why continuously practice that one. Definitely it encourages the knowledge, skills, and you can provide guidance or consultancy services to the others also. IBC, IPA also, particularly the Indian Institute of Insolvency Professionals of ICAI, they are also published one book, Legal Digest of a Disciplinary Case. Here, the IP name is available, IP number is available, IP address is also available, all are available. It is a public notice, it is not a confidential one. The name of the case, the name of the IP, they are disclosing. Once that is reflected, then it will be a problem for us. This is a publication. Now, we will go into the details of the cases one by one. But whatever I told earlier, that is the importance of reading or update the knowledge of the disciplinary committees. Are you getting my point, sir? My voice is audible or not?
Yeah,
Yes, sir.
very
audible.
clear, sir.
Yes, sir.
Audible, sir. Audible, sir. Very clear.
Now coming to one by one case we will deal. The Insolvency and Bankruptcy Code envisages the role of the profession known as insolvency profession. The role of the insolvency is a crucial one. His conduct may affect the interest of various stakeholders. If I am doing wrong, the creditors, operational creditor, class of creditor, financial creditor, workers, employees, and all people in that particular system, the CARP system, the stakeholders, some problem will be there. He may fail to comply the provision of IB rules, regulations, guidelines, or orders issued under. So once I did a mistake, it is not restricted to me. It is affected all the people. And the particular system, CARP is a system, liquidation is a system, PG2CD is a system, PPIRP system, voluntary liquidation is also a system. In that particular system, whoever the stakeholders is there, all will be suffered on account of my lapses, my errors, and if at all I failed to follow the guidelines or regulations. Such an important profession cannot be non-regulated, should be regulated. That person also to be regulated. If at all I leave it like that, he passed the LI exam, leave it like that. No. Therefore, it is necessary to have an objective, credible mechanism which does not spare any misconduct. That disciplinary committee is a strong one, sir. While it does not penalize the honest conduct of the insolvency profession. Suppose the error is a human. That error, if at all it is not given any inconvenience to them, they will give some exemption. Error is a human on account of a volume of transactions. Suppose 10,000 claims are there. Out of 10,000, some errors means everybody will, okay, boss, I understand your problem. 10,000, you have verified one application wrongly classified, or that is not to be admitted. Okay, rectification, everybody will agree for that rectification. If two are there, or three are there, or that three also wrongly classified, then nobody will come into your rescue. IBBI exercises regulatory oversight over IPS. Not only you, IBBI also, whether IPS are doing their job as per bylaws or not. IPS, even IUs also. Because IU, IP, IPA, all these people, they have to register with IBBA. And for these the code of conduct or regulations are there. IPS are also regulate IPS. Dual control, not only by the IBBA, IPA also, like ICSI or ICMAI or ICIA. So they also dual control. Then it strengthens the system. Therefore, IB provides a two-tier regulatory regime for IPs, the IBBA and IPA, which are regulated by the IBBA. The process of disciplinary IP by IBBA is comprised in Section 217, 218, 219, 220. Please go through that one. Or please remember these sections. And occasionally go through that one. Then automatically, whenever we are doing that process, these sections are reflecting elsewhere. And IBC, the Inspection and Investigation Regulation 2017, IBBA inspection. So, in IBBA also, they are doing two types of audit. One is a random, second one is a specific audit. If at all any complaint was there, specific audit. Or out of the total 100 or 200, this quarter, they will randomly select based on some the formula or matrix. They will decide and they will do the. For that also we have to cooperate. The investigation officials of IPA or IBBA. For a case, they will tell this tomorrow we are coming, we have to audit. That's why next week I'm going to address that particularly CIRP audit or liquidation audit. The specific as well as the random. And what papers we have to submit to the investigation authority. And how to maintain the papers and all these things next week or so. I will discuss that one. IBBA grievance and a complaint handling procedure, the regulation 2017. So continuously update or whatever the latest regulations are there, go through that one. Now, the disciplinary cases against IPs. So, if all people are adopting or honoring the regulations or rules or the code or judicial process perfectly, disciplinary committee, no work, nothing. That is required also. That is required. Quality of IBC system in India is number one. Because every profession is, they are maintaining high standards. assignment, before going into the particular case, whatever the IBBA from time to time, these are the mistakes committed by the IPs through circulars are also there and they informing to the IPs. Assignment without having authorization, AFA authorization for assignment. Bankers today they are not verifying. If at all you are in empanel, they will give the cases only. And if at all old person knows about authorization assignment, then he will verify. Otherwise, if at all transfers are there, they will don't verify. Some of the people in the system, the IBC system, particularly the professionals, without AFA also they are accepting the assignment, which is highly irregular. That's why even NCLT also today, whenever they are giving assignment, they are also cross-checking or verifying the AFA certificate also. Because once this problem arises, everybody is tightened from their side also. Regulation 7A of IBBI 2006 IP regulations requires a IP shall not accept or undertake any assignment including CARP unless he holds AFA authorization for assignment. On the date of such acceptance or commencement of such assignment as the case may be. That is compulsory. Whenever I am accepting, okay, I have they visited to the bank, they are given, even in the meantime that credit officer is having good knowledge about IBC. Sir, what about your AFA, sir, whether it is in live or to be renewed? Then if I verify that is lapsed, then it is a image risk. It is an image risk. The bylaws of the IPA provide that if AFA is not issued, renewed or rejected by IPA within 15 days from the date of receipt of the application by the IPA, the authorization shall be deemed to have been issued or renewed as the case may be by the IPA. Okay, you have applied, but 15 days cross remains deemed to be that they have issued they have renewed the AFA. There are, however, instances where IPs undertook CARP without having AFA, which is highly irregular. Okay, that's why every place some barriers are there. So NCLT also they are verifying while giving the assignment or the financial creditors, some banks, are you having that AFA in live or applied? Without even apply for AFA in contravention of the provisions of law, which is not correct. Now, one by one cases we will study that case and what are the irregularities that are committed by the RP or liquidator, etc., etc. Name of the corporate data. Corporate data 1, Lanco Infratech Limited. Corporate data 2, Messrs. Shripur Power Private Limited. Both, one is CARP and the second one is the liquidation. I have not mentioned the IP names here. Only company names I have mentioned. And if you want that IBBI website is available or IPS are also, they have also mentioned in their particular quarterly journal or monthly journal like that. What are the contraventions in these two, CARP and liquidation? What are the contraventions? What are the wrongs or errors that are committed by the resolution professional? Contravention 1 with regard to CD1, Withdrawal excess fees as a liquidator. Even though the powers are with you to operate the bank account, it doesn't mean that as much as I wish to withdraw the funds means that is wrong. You are the trustee. Even 1 rupee extra also we should not draw from the bank account. Withdrawal of excess fees as a liquidator. IP failed to properly calculate his fees according to the regulation. When the same was not fixed by COC, IP further acknowledged the error. Yes. And refunded the excess amount withdrawn. So he agreed, accepted that excess amount he has taken, and he refunded by him to the CD. And the contribution. Contribution with regard to the company, Deloitte Touch. And IP engaged the Deloitte Touch to assist him during the liquidation process. Whenever I am engaging any services, service providers, for what purpose? For what purpose I am engaging the service? Whether need is there or not. The CIRP or liquidation is not for lavish expenditure. The CIRP cost or liquidation cost to be minimized so that the stakeholders in the particular system will be benefited. IP engaged the DTTI LLP to assist him during the liquidation process of the CD. However, the fees paid to them was without clear terms and conditions. Whenever I am engaging the services, service provider, the MOU, Memorandum of Understanding is required or agreement is required. Without agreement, simply I have taken services, lakhs of rupees, not my amount, that is the CD amount. With varying amount over a period of time. Once I am taking the services, why the dynamic fees? Okay, sometimes the dynamic fees is also okay. Where is the agreement? Raising concerns of unjustified payments. DC observed, Disciplinary Committee observed, that IP while carrying out his duties, engaged assistance of the DTTI LLP, which was not in the nature of appointment of profession and contravened the regulation. Whether he is a valuer? No. Whether he is a transactional auditor? No. For what purpose? Earlier also, even when I am in bank also, particularly in the stress research branch, some people, sir, I am engaging the IP. For what purpose? For what purpose you are engaging? Sir, I am engaging, they will charge, I will charge 1.5 and they will charge 2.5. Okay, 2.5 or 3.5, whatever the amount is, for what purpose you are engaging these services? Tell me in detail. No answer. One side clearly tells the cost to be minimized, CIRP cost to be minimized. If this type of errors are there, definitely DC will impose some penalties. So appoint the professions and contravene the regulation. Contraventions with regard to CD2. Failure in filing avoidance application. What is the problem? Once it is clearly defined in the regulation, what is the problem? Why you are giving gaps? Why you are not following the total CIRP regulation? That regulation is clearly defined by the IBBI. The IP failed to comply with the CIRP regulation. but not initiating action required for the transaction review audit. That is a transaction audit. And did not file the necessary application before educating authority. So you have to come to a conclusion whether transaction audit is required or not. Today, what is happening? Some of the RPs by default, there, even though the transactions are minimal and they are not they verifying that one and they have not concluded that some fraudulent transaction. So whenever you are applying to the adjudicating authority, you have to give some proofs. These are the puff transactions during the particular cursory verification, random verification or cursory verification. DC highlighted that IP initial statement of COC that the transaction audit was completed. Why we are giving wrong information? Once it is not completed, what is the problem in telling to the COC? If at all they ask, can I have the copy of the puff transaction or forensic audit transaction means, no sir, I kept elsewhere. Next meeting, I will bring it to that one. This type of, so the transparency, whatever your duty is there, you have to fulfill that. Nobody should pinpoint your duties. He continued to seek information from the management of the CD2, indicating incomplete audit process. So he is asking about the management, some documents, and if at all management is not given, then they're not supporting. You inform to the COC and inform to the adjudicating authority that the management is not cooperating to provide the books. And the adjudicating authority, as per the regulation also, they will directly give some suitable show cause notice to the particular management also. If at all they are not going, they are having full powers to arrest these people also. Moreover, he failed to inform COC about the non-furnishing information by the management to the TRE and did not take any action, seek cooperation from the management. This cessation of the following for the information from the management further compounded the issue. The DC concluded the delay over 4 months in finalizing the avoidance transaction from the 6th COC meeting till the order of the liquidation was not justified. Your boundaries are there, deadlines are there. They have given dates also before that is to be completed. Otherwise, if at all, as per my wish and fancies, if at all I am running the show, 180 days is not sufficient. So as a professional, I should follow the regulations in total without any deviations or mistakes. Penalty. So in view of these two, the penalty imposed is the DC suspended the registration of IP insolvency for 2 years and imposed a penalty equal to half of the amount paid as a professional fees to DTTI LLP. Why you have engaged these services? That too, it is a troublesome company and liquidity problem is there, and once you have taken over the powers from the erstwhile management and you are operating, how much accuracy and independence should be there? You are not a HR manager or you are not a king of that particular company. And why you have engaged the services of service provider, which is not required? Then half of the fees paid to that particular service provider, that is also to be deposited in consolidated fund of India, the government of under the head of penalty imposed by IBBI. That is the https bharatkosh.gov.in within 45 days from the date of order. Why should we invite this one? 2 years means after that also nobody will believe. The brand is always be there. The brand is also reflected in the IBBI website. Anybody can view that one. Today, if at all I am going to IP and how many cases are there handled, all these things, and if at all any the red marks are there, that also they will put it in the website for public.
Sir, one doubt, sir. Sir, one doubt.
Tell me, sir.
Yeah, sir. Normally, even I have dealt with Deloitte in my earlier company. They won't take any assignment without the proper agreement, sir. Normally, that's what I have seen. So I don't know how this happened also.
Yes, sir.
Quite surprising.
Yes, correct. Sir, purpose is there. Suppose take, for example, you require some secretarial service, sir, for you.
Okay.
In the
No,
company,
whatever, sir. Whatever
in the
service,
company, excess staff is not there. And you can engage the services of any secretarial service, company secretary or extended company secretary for writing the particular minutes or resolution, whatever it is, they take. But whenever you are giving any offer letter to him or her, then some agreement is here. That is
correct,
also
sir.
missing. That is also missing.
No, very surprising, sir, because a company like
correct.
Deloitte won't take anything without assignment. Okay.
Correct.
First of all, I don't know why he went to Deloitte, very expensive. There are hundreds in the market.
That is also reputed company, na? Standard company, reputed company. Deloitte means
No, they
multinational
charge very
company.
highly, sir. They charge very high fees.
Correct.
I don't know. Anyway,
Well,
in these, whatever you discussed, what service was taken also is not clear.
Correct. So the details, the order, particularly if you go through the order, sir, all are clearly they will mention. But this is only a synopsis. This is
Yeah,
only.
I understand it's a synopsis, but okay. So, thank you.
Case highlights IP failures to effectively manage a CARP process, leading to withdrawal of excess money, delays, and a non-compliance with the regulation. So, what are the learning lessons in this case? The learning lessons are: the findings underscore the importance of adhering the timelines, maintaining the transparency with the stakeholders, and taking decisive action to address the non-compliance issue during insolvency proceedings. Second point. 1.1 case. Fees payable to IP. Fees payable to IP. The code of conduct of IP under the IP regulation requires that IP must provide service remuneration which is charged in transparent manner and is a reasonable reflection of the work necessarily and properly undertaken. So, transparent manner, in addition to reasonably reflection, in addition to the work necessarily and properly undertaken. Regulation 33 of IBBI, 2000 CARP regulations, requires applicant shall fix the expenses to be incurred on or by the IRP. Regulation 34 requires committee of creditors shall fix the expenses to be incurred on or by the RP. And Regulation 30D requires COC to fix the fees payable to the liquidator in the event of CD proceeds for liquidation. The fees payable to an IP was not fixed beforehand, and the IP drew the fees on his own without approval. of such fees from the competent authority in contravention of the provisions of the law. But what is happening? They are withdrawing without any approval and other things. Names of the corporate debtor. Another case, Falcon Consultancy Private Limited, the CD1, Global Coke Limited, CD2, Saraswati Sales Private Limited, CD3, Dayal Commercial Company Private Limited, CD4, and Ashes Smelter Private Limited, CD5. Contraventions. What are the various contraventions in this case? Non-appointment of valuers, CD1. IP failed to properly appoint registered valuers to determine the fair value of the assets of the CD. The valuation was done at the behest of someone else other than the authorized IP. Also, no valuers were appointed, and IP misled the board about the appointment. Once a clear-cut regulations are there, and get the approval for the fees to be paid to the valuers, the COC only. And once someone is else other than authorized IP, and that is not to be accepted. That is in CD1. CD2, non-appointment of valuers. IP remind IRP. IP remind the IRP for CD for a period of 60 days. And did not appoint any valuer, citing that he had only replaced by another IP for further proceedings. In that case, if at all you are appointed IRP, no, anyhow, RP will come, sir, he will take care of. That's why I have not given a public announcement like that. Means, is it acceptable? Sir, anyhow, the IP will appoint, sir, in place of me. Then he will appoint the registered values, not me. Please wait and see. So, up to last date, during IRP, you have to discharge your duty as per the regulations. And anyhow, that person will come, this person will come, he will take care of, he will look after. That type of wordings are not there in the regulations. Next, CD3, non-cooperation of IP for conducting inspection. So the random inspection, the specific inspection, random and specific inspection. Once the IBBI or IPI has a telephone to you that I am coming to your place and we are going to verify the cases handled by you. The case name is this one, that one, like that. You have to be ready. The papers. Because as and when the inspector is asking about a particular paper, retrieve that one, give it to them. Once that is completed, you place in that particular box file in such a manner it should not be disturbed. And if at all he requires any Xerox copy, give it to them. So the IBBI is the ultimate authority. Or IPA, dual control. The IP did not cooperate with the investigation authority in submitting the reports to the COC meeting and mistook that for stakeholders committee minute reporters. Whatever the papers they are asking, if at all it is a part of regulation, we should mobilize and we should give the information. Otherwise, in his report, he will mention all these gaps or whatever it is there. Accordingly, he will submit the report to the DC also. Delay in filing the relationship disclosure. Relationship disclosure with respect to appointment of valuers. Once you are finalizing he is not my friend, he is not my related party, what is the problem? If at all that is not there, uploaded in the website of a CD. after delay of 2 months. Because these people are not aware of the system properly, or the negligence. Delay in filing of the relationship disclosure, CD4. IP was confirmed that RP, but same was uploaded upon the website after 8 months. Why that even the CARP 180 days only, that 90 and 60 is exceptional circumstances, not straight through process. Delay in appointing the valuers, CD5. The valuers are to be appointed after inordinate delay of 84 days. Why 84 days? As per the regulation, within 47th day. Why has taken almost double? Because his other professions also there. That's why he is delayed that one, violating the prescribed time framework enumerated in the code. The DC, while hearing the written and oral submission of IP and reports IA, the investigating authority, observed that overall conduct throughout the service rendered in the causes of CDs contravened various provisions of the code. So that's why audit is also very, very important. So in the coming days, the number of audits will increase. Even they will choose from the IP source, or those who crossed the 70 years, they will choose and send it to that particular. If IBBI is not submitted, they not allocated that audit job to their staff members due to shortage of staff, they can they may outsource that one also, or through artificial intelligence or machine learning or application program interface APIs. Even off-site is not required. Even on-site is not required. Through off-site also they can do the audit with the accurate. So through the services rendered, so many mistakes, penalty directions. What penalty has given? As a registration of IP already cancelled, the contravention heard in the present case pertain to prior and involved several non-compliance in multiple assignments. Therefore, in view of the contraventions, the DC imposed a penalty of 2 lakhs on IP and directed him to deposit a penalty amount directly to the consolidated within 45 days. So we should not invite criticism from the regulators. What are the learning lessons? In conclusion, the detailed examination of IP action reveals a pattern of non-compliance and delays in filing, fulfilling his responsibility as an insolvency professional in various, from the failure to appointment valuers, promptly to delays in filing the relationship disclosures. IP actions violated the regulatory guidelines and the code of conduct governing the insolvency proceedings. So this type of situation should not arise. Very few people, because here monthly 2 or 3 means on an average 24 people they are not doing, and others are doing well. But whatever the mistakes are committed, if at all we have also go through that one, definitely the skills will increase. That type of errors may not repeat in our assignments. These contraventions reflect a lack of diligence and attention to procedural requirement essential for the smooth conduct of CARPs. Overall, the findings highlight the importance of strict adherence of the regulatory framework and times the insolvency to ensure the transparency, the fairness, and the protection of the stakeholders' interest. IP contraventions serve as a reminder of the critical need of the insolvency professions to uphold the highest standards of the profession and regulator compliance in their practices. Next one is cooperation. After that, we will break for tea for 10 minutes. Cooperation. CIRP requires the cooperation of the city. Otherwise, where the books, who is the Kratos, who is the Datos, and what is the process, or the production head, what is his role, or all these things. If at all I am asking production manager also, he don't reveal. But the CD has to provide full information to the IRP or RP. The promoters, the suspend directors, and management. However, cooperation may not forthcoming in all cases. They don't give because the powers are cancelled, and now they don't have any power of signing the checks and the power to the power of authority on the employees or officials, etc. Section 19 of the code, therefore, enables IRP or RP to file an application to the adjudicating authority in case of a non-cooperation for direction. If at all anybody is not cooperating, particularly the erstwhile, the directors or promoters or management, if they are not discharge their duty, they discharge their duty, that is a cooperation not to be extended to the IRP or RP, then immediately the IRP or RP, they have to file an application with the adjudicating authority to such a person to comply with the instructions of IRP and cooperation with them. Since the time is the essence, 180 days, countdown started. Day 1, countdown, 179, 178, 170. The countdown starts and I have to discharge my duties and complete the task within 180. Within 180, not the border of 180. 90 and 60 is different. The IRP or RP must act with promptitude. Once he is not supporting, if at all he is sitting idle, and later on, if at all Siva says, sorry, he is not supporting. Once it is a regulation is there, once the CDs are not cooperating, immediately escalate the issue to the appropriate authority, that is adjudicating authority, and file the application wherever required without any postpone. Today I will ask. Tomorrow, second time, third time, fourth time, immediately. Some other people, what they are doing means without any efforts, they are simply escalating the issue to the adjudicating authority. That is also not correct. From your side, whatever efforts are to be made, you made, and then only if it is not a fruitful exercise, then escalate. There are instances where IRP or RP failed to file such applications or filed so late that it lost its purpose and effectiveness. Any delay in filing application, despite continuing non-cooperation, may reflect undue influence of the promoters on the IRP. So in the meantime, undue influence will also start. What is the name of the corporator? Ratnadeep Infrastructure Private Limited, CIR. What are the contraventions? Constitution of COC with the related parties. One side, there are IBBI regulations and judicial pronouncement. Always with the mic, they are telling no related party should be there in the COC. That is the basic criteria. IP appointment as a director in a Tirupati Balaji Fibers Private Limited and Silver Tone Private Limited during the CIRP of the city. He is a director. In the, particularly, this is with regard to substantial share 10%. Held a directorship with the IP in the same above mentioned company constituted a violation of the code. Suppose once I am agreeing or any related party is there, any board of directors known to me or my relatives are there in the company, I have brought to the notice of the adjudicating authority within 3 days. But he is silent. Once he is the sister concern, whatever it is there, he is the board of director. RP himself is a board of director. How the independence will happen and how the accuracy of the CIRP will happen? IP further submitted the concern raised against him and undergone thorough examination and adjudication at various judicial levels, including Honorable NCLT's, Honorable Supreme Court and adjudicating, which upheld his conduct as a liquidator in accordance with the code. In reviewing the events, DC observed IP acceptance directorship in a company connected to the insolvency entity compromised his independence as an RP. Despite subsequent resignation from the directorship, the DC determined that his conduct raised doubts about the profession independence and integrity. Once he is the director of the sister concern of the insolvency company, how he will give a correct CIRP process? Penalty directions. DC suspended IP registration. Completely registration cancelled. Insolvency for a duration of 3 months. So you should not act as an IP for 3 months. Learning lessons. The disciplinary committee found insolvency professional appointed as a director in connected companies during the insolvency case to be violation of the code of conduct. This contravened several regulations and clauses in spite of the IP argument about the past legal proceedings upholding their conduct. DC concluded the accepting of the directorship in connected companies comprising IP, independence and integrity. Now, we will take 10 minutes break, sir. Sir, is it okay?
Okay, sir.
Okay, sir. Okay, sir.
Now, the next one is a public announcement. Section 15 of the code, read with Regulation 6 of the CIRP, requires a IRP to make public announcement commencement of CIRP within 3 days of the appointment. Such announcement required to be made one in English and one regional language with a wide circulation at the local location of the registrar office and the principal office of the seat. This enables the creditor to submit the claims to IRP and considerations such as claims by the authorized stakeholders while resolving the stress of the steady. So some of the IRPs, even this also they are not following strictly, not make public announcement promptly on his appointment, or made it later, or made it in one newspaper, or made it in one English newspaper having circulation at the location of the city. This is not only puts CIRP at risk, but also deprives the stakeholders of their legitimate rights. This is happening. This is IBBI version. Name of the corporate data, Monica Electronics Limited. It is under liquidation. What are the contraventions? Anomalous and non-transparent of sale of assets of the city. The liquidator issued a sale notice for e-auction, which was adjourned twice and ultimately conducted. During the e-auction process, the liquidator found 4 bidders ineligible. Once ineligible, what are the reasons for ineligibility? That is to be disseminated to the participants due to collusion, yet failed to communicate this to them until after the auction conclusion. Additionally, the liquidator did not submit a report to the adjudicating authority regarding the collusion among bidders as required under Regulation 33(3) of the liquidation regulation. IP failure to conduct auction process transparently, communicate updates clearly, and maintain written records of the decisions was considered a contravention of the regulation of the code of conduct. The disciplinary committee that IP communicated ineligibility of 4 applicants 1 day after conclusion of the bidding process. This disqualification based on the suspicious of collusion was deemed inappropriate. Next, the evidence provided was insufficient. How they are colluded? You have to tell something, why they are colluded and why you are believing that they are colluded, and the disqualification limited to competition. Only 2 bidders participated, 4 hours, contrary to the intent of the liquidation regulation. The DC further disagreed with a narrow interpretation of Regulation 33(3), emphasizing that regulation aimed to prevent collusion and promote a fair competition. Okay, they have mentioned. But under what circumstances you have believed that they are colluded with each other? Any proof? Nothing. So once we are commenting any other remarks, that proof is to be established, or that particular information to be recorded properly. The DC also criticized IP for disqualifying bidders without giving them an opportunity to cure the defects in their application. Suppose if at all any defects are there, even if at all application submitted to NCLT, any remarks are there, any defects are there, as per the code also, they can provide some the time to rectify the defects. It is not mandatory. It is not a mandatory one. So, like that, here also, if any sufficient small errors are there, give them time and they give scope to rectify them. Then, if the number of the participants are more, the value maximization is possible. Next, IB further failed to provide evidence that the disqualified builders were duly informed before e-auction date, casting a doubt on the transparency of the process. The DC question, the benefit of a limiting auction only to bidders, suggesting more participants could have lead to better value matching. But in this case, that was not happened. What is a penalty or directions given by the DC? The DC suspend the registration of IP for a period of 2 years to run consequently from the expiry of the previous suspension order. Already that person is suspended. From that date, 2 years, they have given the judgment. Learning lesson. IP failed promptly communicated ineligibility bidders, raising transparency or concern. Is a further disqualification of bidders based on suspicion of collusion was deemed unfair and limited to competition. IP gave no opportunity has given to the bidders to address the application issues. IP actions contravened the liquidation regulation and the code of conduct. Updating the list of claims. This is one of the important area. Lot of complaints are arising in this area. Claims. Once the claims are received, it is to be verified properly with the proofs, with the books of records that are available with the corporate data. If it is a financial creditor, interest is to be calculated correctly or not. And if at all the interest is a monthly compound or a quarterly compound or a half-yearly compound or yearly compound, that also to be added. Otherwise, the voting rights, 1% that side or this side is also dangerous. And even operational creditor also. Whatever the invoice, suppose one operational creditor filed an application. First and foremost, what is the invoice raise? Before invoice raise, what is the bill of exchange that is accepted by the corporate data? The bill of exchange to be prepared by the operational creditor, accepted by what are the days? And beyond all these things, the stale claims are also admitted. So once the bill of exchange is more than 3 years, if a proper acknowledgement is not there, as per the limitation, earlier we have read that 18, it is invalid. We should not admit. Even though bill of exchange is there, that is a stale bill of lading, invoice, all are invalid. Once the bill of exchange is there, live, followed by invoice, followed by goods received, beyond all these things, the purchase order, PO, purchase order requisition by the company, followed by the particular bill of exchange, followed by invoice, followed by acknowledgement of goods. Once the goods are received by the corporate debtor, he will acknowledge, the storekeeper will acknowledge. Not only that one, once the goods are transported from transport vehicle, whether it is a lorry receipt or railway receipt or the airway bill of lading, if airlifted, or bill of lading through ship, that Xerox copies are also to be attached. Then only it is a correct proof. Then this amount to be matched or cost checked with the company's creditors also. And if at all any delays are there, rate of interest is there, the rate of interest are also clearly to be mentioned. Then only, even bankers, whenever they have at the insolvency commencement date, some of the banks up to the claim filing, they are calculating the rate of interest, which is not correct. Up to the insolvency commencement date only, they have to calculate the rate of interest. Then, if at all we have not verified properly, or verified even interest also not verified properly, if the crores of rupees the difference is there, the particularly voting rate calculation also wrongly calculated. So that's why here a lot of scope is there for complaints. If at all we are not admitting, even segregation. Operational creditors are not to be they mentioned in the financial creditors are not to be mentioned in this one, and within the financial creditors, so who is the secured, who is the unsecured, within the financial creditors, so who is the secured, unsecured, and related parties also. So once the related parties are there, then they are not having the voting right, or the voting, they are not the part of the COC. And even the class of creditors like bonds, the debentures, and the fixed deposits, all these things are class of creditors. Even in home buyers also. So the home buyers also properly verified how much he has given payment, what are the vouchers, whether it is NEFT or RTGS or check, if at all paid, the account statement, all these things are properly to be verified. Updating the list of claims is a challenging one. If at all it is not addressed properly, then the problems will arise. Section 25(2)(e), read with regulation 13 of the CIRP regulation mandates that IRP or RP shall verify every claim as per the timeline and maintain the list of creditors containing the name along with the amount claimed by them, the amount of the claims admitted, and security interest, if any, in respect of such claims. Update the list and display it on the website, if any, of the CD. So once the claims are admitted, display in the corporate website, company website, corporate data's website, and it is subject to changes. Later on, it may increase or it may decrease also. And after getting the full proof, then sometimes it is a dynamic one. IRPs or RP display and update it in the CD website. That is not following. Name of the corporate data. Action Ispat Power Private Limited, CIRP. What are the contraventions in this case? Non-conduct of COC meeting despite several communications made by the creditor. What is the problem in not conducting? You are paid for that. That importance, that to the financial creditor request, and creditor has having more than, if 1/3 voting right is there, if they made a request, you have to. In this case, the voting right is 59.1111. Why you are bypassing? And the COC is your boss, and contravening the regulation of 18(3) of the CIRP regulation. The financial creditor made the proposal for making the notice period shorter, convincing the COC from 5 days to 48 hours. So adequate time give. And the financial creditor made proposal. Financial creditor made proposal for making notice for shorter period also, that is there. And however, same could not be implemented by ERP. Why? What is the reason? Why you have not they conducted? Once the request is 1/3 of the voting right people, they requested to conduct the COC meeting. What is your objection? Due to the pre-occupancy with respect to safeguarding the assets. What is a pre-occupancy? You are the security guard. Pre-occupancy with regard to safeguarding the assets. You are not the security guard. Your security guard is different. And that is paid for that. That is also CARP cost. That is also priority. So, DC will not accept all these things. Kahani, they don't accept.
Yes, sir.
So if sir?
That is 33% voting. That is 59.11. What is this figure? 59.11?
No. Yeah, actually, if 33% people are asking, then the COC can be conducted. But in this case, the voting rate is 59%, 59.11% people requested.
Okay.
If 33 is sufficient. But in this case, 59.11 people, one person is having 59.11% voting rate. If at all he made a request, definitely. And pre-occupancy with respect to safeguarding.
Sir, I have a small doubt, sir.
Sir.
Sir, CD has two financial creditors. One financial creditor has submitted a claim of Section 7 claim was 7 crores. But the admitted claim by RP is 73 crores.
7 crores or 73 crores, sir?
7 crores. The RP admitted 73 crores by calculating the interest on the date of NPA, and it becomes 73 crores. And that financial creditor, by virtue of this admitted claim, he got 70% of the voting rate. Only to get him higher right, RP has admitted higher claim. Whether we can challenge it before NCLT or what is the remedy, sir?
Sir, insolvency commencement date is
ICD.
Okay. Second one is whether it is a hypothecation agreement or mortgage deed or a demand promissory note, whatever the rate of interest they have mentioned, that is to be taken. Second one, once the account is NPA, turn into NPA, the system will stop the calculation of interest. But in almost all banks, accrued interest is also calculated by the system. That is not debited to the account and credited to
not
the
realized.
Not realizable. So, whenever insolvency commencement date means, if the particular case is admitted on so-and-so date, the financial creditor, whatever the outstandings in the account plus on that day accrued interest, they will add and they will take the screenshot, they will take the printout and stapler it and send it for the admission.
They have added penal interest charges.
That penal interest of 2% or whatever it is there, if that is there in the terms and conditions of the loan, that is also to be added. That is also to be added, sir.
But the amount is, it seems that the amount is increased 10 times, sir.
No problem, sir. Sir, take for example, sir, documents are live, sir. 10 years back only, that the surface after the DRT, now IBC. This 10 years, the rate of interest to be the calculated.
Okay, sir.
7 crores, 73 or the compound interest.
CD is claiming that his calculation is wrong, and by virtue of his calculation, one financial creator got the voting rights of 70%.
Correct.
So whether it can be challenged before NCLT?
Sir, that's why, sir, first of all, from IP side, the RP side, you have to be cautious more. Casual approach is increasing, sir. Calculation. Suppose you have submitted one claim. Then SAR is submitted one claim. Whether the SAR is a creditor or the liability side in the balance sheet books is there or not. Okay. SAR mentioned some principal and rate of interest. Principal, whether DP note is principal matching or not. Interest. Interest from up to date. That is whatever the rate of interest, monthly compound or a quarterly compound, whatever it is there. I have to calculate all these things. Then only I have to display in the website, sir. Today, it is not properly calculated. Now, honestly speaking, if at all you have given that job to me, 50% of the cases that is wrong, sir. Particularly financial criteria, interest rate calculation.
Interest, they are charging interest on interest.
That is correct. That is sometimes they mistaken simple interest. Sometimes if at all simple interest clause is there, they are calculating compound. All these things. Definitely, I am telling claims admission, because here RPs are trusting some people. That trusted person, they based on that only there. Even that's why the CIRP audit, anyhow, I'm going to take the class. Auditors, they are pointing out this type of the claims admission, number of wrong things.
But whether, if you have, CD has any doubt whether he can challenge before NCLT or it is the sole discretion of RP IRP as per IBC.
Sir, one thing, sir. Suppose the CD verified, but instead of 3 crores, the claim admitted 30 crores. 27 crores, etc. Then immediately CD can file an application with an IA with the NCLT. Sir, the claim to be admitted for 3 lakhs, whereas RP allowed 30 lakhs, 33 crores, 30 crores, 27. Once that is happening in the waterfall mechanism, so whatever the amount is there, if they paid extra, then they will come to me again for personal guarantor to corporate data also. 27 crores is not a small amount. And if he is, whatever the proofs are there, if he mentioned all the proofs are narrated him, definitely 100%. The DC, first DC, the NCLT, they will give a strong dose to the RP. Why you have negligent in admitting the claims? Second one, then they will escalate the issue IBBI also.
And what RP is telling, verification of claims and admission of the debt, claim amount, is the sole discretion of the RP.
No. What is the sole discretion, sir? It is subject to agreements. It is subject to terms and conditions of the loan. If at all I have, suppose take for example, I have not supplied stocks, but I have raised one invoice and submitted. With his sole discretion means if at all he is accepted? No.
It is subject
available
to
record.
loan agreement.
That's why in the regulations also with available records, underline, available records or books.
Regulation 14, sir. Is it regulation 14? Okay, sir.
However, same could not be implemented by IRP due to preoccupants of the safeguarding the assets of the city. Some reasons they will tell which is not relevant to that particular irregularity. Penalties. Take lenient view and issue warning to be careful while handling the assignment and ensuring the compliances to be made with the provisions of the code and regulation. Code and regulation. Learning lesson. While RP reasons for delay were acknowledged, her failure, lady, to conduct the meetings requested by the financial constitute a violation of CIRP regulation. One third people are requested how to conduct, but in this case, not one third, it is 59 point and odd, which is a gross negligence. Authority of COC. The code reads with the regulation specified responsibility of IP and of the COC in CIR. These required additions, several matters. COC is required majority of the voting share. No creditor, whether secured or unsecured, irrespective of the voting share, or no pool of the creditor, such a joint lenders firm is a substitute of the COC. Today, what is happening? Suppose you are having your financial creditor having a 70% voting rate, and I am having 5%. Another 5 people are having 5%. The IP and the RP is neglecting the 5% people and always hello boss, 70% people only is mingled with the. In that case, what is the independence of RP? Okay, by virtue of the higher amount lending by one financial creditor, so more than 66%, you should not be make a friendship with them, and 5% people, whatever their arguments are there, you are neglecting or not implementing, which is not correct. In few cases, IP took directions of the creditor have significant voting power. He is listening those who are having high voting power. They are completely neglected the other people. This compromise of independence of the IP and amounts to contravention of the provisions of the name of the corporator. Simi Jewels, Dhanalakshmi Electricals Private Limited, CIR. What are the contravention? Contravention 1, CD1. IP conducted auction of the assets of the liquidator and despite the discrepancies in the auction notice and objection raised by the sole stakeholder. This lack of transparency and fairness of the auction process contravened the code of the principles and value maximization. And stakeholders would also criticized by NCLT or NCLDT because of irregularity and hasty decision taken by the RP. The IP made a delayed public announcement after CD has undergone CIR. So, announcement further contained inconsistent of submission of guidelines, lack of clarity, thereby contravening the established regulations and code. Penalty. Suspension of registration as an IP and for a period of 2 years. Learning lessons. Inconsistency in conducting the auction during the sale of CD1 assets and a violation of regulations related to issuance of public notices in CD2 lead to suspension of registration. These actions further underscore the importance and adherence of the regulation and transparency in the insolvency proceedings. Appointment of professionals. Whether the valuer is a professional. Transactional auditor is also a professional. And class of creators are also IP professionals. It is a duty of the RP to preserve and protect the assets of the CD, including continuing its business operations. Section 25(2) of the code empowers RP to appoint accountants. He can appoint, if at all accountants are required, legal people, if at all required, and what are the reasons, what is the rationale for recruiting of legal people and other professionals for this purpose. Clause 23B of the code under the RP regulation prohibits IP from the engaging or appointment of his relatives or related parties for any connection with the work relating to of his assignment. In some of the cases, particularly if you go through the orders of the DC, and they are appointing the relatives also. And later on, it was pointed out by the corporate data or other people like that. An IP is therefore required to satisfy himself that there is a need for service. If at all the puff transactions are not there, immediately he confirmed to the adjudicating authority and he can withdraw the transactional audit also. But by default, all CIRPs, puff, even the records are not available and puff transactions are initiated. If records are available, then only the transactional auditor will verify. If the books are not available, how he will give the report? Simply paying the 5 lakhs or 2 lakhs or whatever the amount, depending upon the size of the company. Such services are not available within the CD. Suppose the finance department is there. Finance department also, if they are competent, then you take the assistance of them instead of taking the accountants from outside. The person qualified render professional service. The profession should be appointed suitable for this purpose. Suppose valuers, not the general valuers, those who are registered valuers organization, that is a land and building or plant and machinery or the securities valuation, whatever the IBBI regulation states. The profession is not related or related party. The fees to be paid to the profession is a reasonable one. It depends upon the size, the quantity, the work, quantity of the work. If at all that is only a 6 months period or 1 year period, then you have to reduce the fees. Lavish expenditure should not happen. He must not appoint any person who is not a professional. Even the particularly transactional auditor, some qualified people are required. Who is a relative or related party, who is a choice of the stakeholder. He must not appoint a professional provider service stakeholder or professional because of the stakeholder wants the professional to be appointed. This compromise of independence of the IP as well as that the professionals impose avoidable cost on the CD and other stakeholders. So this type of incidents are happening. That's why IBBI issued the circular in this regard. Name of the corporate data. Trading Engineers International Limited, CIR. What are the contraventions? IP challenged the maintainability of the disciplinary committee proceeding and show cause notice. He is challenging. Some of the people, they are approaching the High Court also. High Court also. The disciplinary committee, they are imposing this penalty, all these things. He further stated, board did not share its prima facie opinion before issuing a show cause notice. The IP is telling. Also, same was filed beyond the prescribed time limit. He is arguing, challenging. The IP is challenging about the DC's intervention. The disciplinary committee further examined the alleged contraventions made by the IP with respect to his professional misconduct. discrepancy related to CD's status MSME acceptance of an ineligible resolution applicant and not communicating the same to the COC. Discrepancy related to the CD's status as MSME acceptance of an ineligible resolution applicant and not communicating the same to the COC. Selling of CD's asset without approval of the prior consent of the COC. The RP or IP is doing like that. Penalty, suspension of registration as an IP for a period of 2 years. Learning lesson. The DC examined the challenges made by the IP and found no infirmity in the show cause notice issuance. It stated that board is empowered to consider any material regarding alleged misconduct service providers. The issue of surrounding a resolution applicant eligibility, the premature handing of the corporate data to a prospective resolution applicant, and unauthorized sale of a CD's asset without COC consent underscore the serious irregularity breach of the IPs. The disciplinary committee findings highlight the IP disregard for due process and regulatory compliance, undermine the integrity of the insolvency resolution. It is the duty of the IP to uphold the principles of the transparency, accountability during the insolvency proceedings. Appointment of registered valuers. So all values are okay. They have completed RVO examination, the two IBBI examination, and experience. Some of the values are having experience in certain sectors, the chemical or textile or pharmaceuticals. So if the relevant experience is there, they can give the accuracy of the report. Today, what is happening is some of the corporate data, they are approaching the NCLTs or adjudicating authorities that valuation is wrong. Okay, valuation is wrong means some basis they have to, the evidence and all these things are to, simply the NCLT also will not accept. But most of the cases are valuation wrong, like that. So the appointment of registered valuers. Regulation 27 of CIRP regulation envisages estimation of a fair value and liquidation value of the assets of the city. These values serves as a reference for evaluation of choice, including liquidation and a selection of the choice that decides the fate of the city, consequently of the stakeholders. A wrong valuation may liquidate an otherwise viable city, which is a distress of the economy. Once the liquidation means the death of the company. Given the importance of the valuation in CIRP, the CIRP regulation requires fair and liquidation value shall be determined by the two valuers. It is the duty of the RP to appoint RVs registered valuers, that to IBBI only, not by others. RP appointed person other than RVs for conducting of a valuation, and in some cases, the appointed only one RV instead of two RVs. That is also one RV. Why one RV? Once there is a provision in regulation to, if at all wide variation is there, the variation is also not the exceeding 25%, then only the third value is required. What is the problem in appointing a less number of the registered values? Next, the second one, if at all they are not competent, don't appoint. Otherwise, the total system of the IPC will. So the valuation is very important. The valuation is very important. Name of the corporate data. And what is it? Ambience Private Limited. the CIRP case. What are the contraventions? Failure to protect and preserve the assets of the CD. IP did not try. IBC did not try to reverse an unauthorized completion of the agreement of the post-CD's admission in CIRP. IP did not try to reverse an unauthorized completion of an agreement post-CD's admission into CIRP. IP, however, submitted a routine transaction and helped to improve the project completion status of the CD. Non-publication of a public announcement on the CD's website. IP did not take any necessary steps to publish announcement of the group website of the CD. Also did not take any reasonable measures aware of himself about the existing website. So here he has to protect the assets of the CD, and penalties warrant IP to be extremely careful while handling the assignment and ensure full compliance with the provisions of the code and regulation thereunder. Learning lesson. The disciplinary committee found IP to be violation of certain regulatory provisions related to his duties as an IP. He failed to fulfill certain obligations, including protection and preservation of the corporate debtors. Once you are handling the case, you have to visit all the company premises, whether safety is there for the company's assets or not. If not, create the safety by incurring some amount, which is the CIRP cost. If at all the company is having the number of other branch offices or other sites also, you are having every right to visit, because you are the head of the company. And proper publication, public announcement. However, the committee lenient view asked IP to be careful in his approach for future endeavors. So assets are to be safeguarded by you only. By you only means you are not standing and say they safeguard the asset. Proper deployment of the security that is required, and instruct the security officer of the company and how many locations the assets are there, and where the plant and machinery or stock or any valuable assets of the company located. And outsourcing security, take the outsourcing security. And the location, the asset value, all these things, in some cases, even security is also not sufficient. Even security is also not sufficient. In that case, take the insurance policy also. In case of open yards, lot of raw material may be there, open yard, lot of raw material is there. Okay, one or two security may not be sufficient, but insurance companies are also, they are also giving some insurance policy for theft or the burglary, etc., etc. So cover that one. That is also the safetiness of the assets and the plant and machinery. That is also required. Professional services. IP and every other professional he appoints are independent professionals. They need to be paid reasonable fees, commensurate with the services. Such fees must be agreed before the appointment. So the agreement to be reached, the memorandum of understanding or agreement to be reached, and what type of services is going to be provided to the company, and if at all any deficiency of service is there, how much penalty to be reduced. All these things are to be in the pakka manner by taking the legal experts of the company. In most of the company, legal experts are also available. IP and the professional must be raise bills invoice in his name only towards such fees, and such fees must be credited to his bank account. Once you are taking the services of the particular service providers, the invoices that to be raised in their name only. But what is happening? The any payment fees or service of any IP or other professional appointed by IP to any other person other than the IP, such a other professions in case does not form the part of insolvency. Some IPs, what they are doing means they are booking in his name and they are giving some amount to them, which is not correct. In that case, it is not the part of the IP or the professional concerned must raise the bills and invoice in his name towards such a, and such fees must be credited to his bank account. But what is happening? IP's name only some bills are paid. But what is the hidden agenda? That is also they will look into, particularly the DC committee. Name of the corporate editor, the Steel Hypermarket India Private Limited. What is this case? Contravention. RP authorized a former director to represent CD and engage advocate. RP authorized former directors to represent CD and engage advocate. IP allowed directors to represent in ongoing litigation initiated by the suspended management against the data of the CD without seeking prior consent from the COC. Why you have not taken the COC? Whatever you are not, you don't have the financial powers. Financial powers, the delegation of financial powers are not there. All financial powers, whether you are appointing any transaction auditor or valuer, whatever the fees and all these things are legal, all are to be approved by the COC. But without informing to the COC why you have appointed and why you have paid, consequently the board issued a show cause notice against IP for alleged violation of his duties enumerated in the code. IP submitted such step necessary for effective management on the ongoing litigation and a recovery of dues. So once a show cause notice is given, they will tell so many stories. But whether the other party, the disciplinary committee also having full knowledge about the guidelines and the regulations and the code, because they are giving the punishments or the whatever the punishments they are giving. So they are better than us. So once we are giving any reply to the show cause notice, we should be alert. And another is a delegation violation of a statutory moratorium and the COC approval mandates further jeopardize the assets of the CD. Penalties, suspension of registration of IP for a period of 1 year. DC instructed the board to further notify the headquarters of the Indian Bank, the majority shareholder, regarding the serious violation of concerning the director of the suspended management role in compromising the asset without COC approval. Further, the COC is headed by the Indian Bank only, the financial creditor, for its representatives being a passive onlooker and apparently a serious violations. Learning lessons. The decision underscored the importance of adherence and regulatory guidelines, ethical standards within the insolvency framework. It is also emphasized the need of the transparency and accountability in the management of the distressed company to safeguard the interest of the creditors of the stakeholder. The matter also brings complexities, challenges involving the navigating the CIRP framework while balancing the interest of the various stakeholders involved in the resolution process. Disclosure of fees and relationship. Some of the people they are reluctant to mention the how much fees. Is it? It is a mandatory. It is also clear-cut guidelines are there. How much fees you have taken, and out of that also you have to pay some amount to the IBBI also. So the disclosure fees and the relationship. The CIRP regulation requires IRP or RP make relationship and cost disclosures in the matter required by IBBI. And it is a duty of the IP to disclose the fees payable to him as well as the fees payable to the professional engaged by him while performing the duties of IP. It is also the duty of the disclosure relationship has with the professionals engaged by him. This ensures transparency and enables the stakeholders to take informed decisions. Failure to disclose these details create a suspicion in the minds of the stakeholders about the impartiality and the objectivity of IP and the possibility conflict of interest you may have. The name of the corporate data, Gushi Farm Fresh Private Limited, the CIRP contravention. Lack of due diligence in verification of claims. If you see the DC, Disciplinary Committee, 25% of the cases are lack of due diligence in verification of claims. We should be alert in that particular area. The alleged contravention revolves around the non-verification of the claim of the financial creditor during the CIRP process. Why it is not verified? Even though financial creditor, particularly the system will calculate interest up to standard asset. After the account turn into non-performing, the system will not calculate. Second one, some of the banks, the accrued interest is not properly calculated. So in this scenario, even though bank is submitted some claim, don't believe that the bank is correct. The financial creditor is correct. Why the penalty is imposed 2% or 4%? Whether is there an agreement for a charging penalty or not, that is to be verified. That is to be verified. The contravention around the non-verification of claim by the financial creditor during the CIRP process. Particularly in CIRP or liquidation. Liquidation also, liquidation commencement date only, you have to calculate the claim. Perfectly calculated. Mathematical accuracy is required. If at all interest is there, what is the interest? What is the compounding interest or simple interest? And what is the penal rate of interest? What are the other charges? All are to be properly calculated. Even banks are also, whenever they are filed with the OA, original application with the DRT, we will give the split, the principal amount how much, the interest how much, whether interest is simply simple interest or compound interest, and what is the rate of interest. If at all I have calculated additional penal rate of interest, what is the penal rate of interest, how much amount, the total, and for that the account statement is also to be submitted. As per the Book of Evidence Act, banks are to be submitted account statement duly signed by the authorized official. That is to be accepted. Or simply claim this much amount not correct. The details, the supporting documents also. Suppose I take for example 12%, whether it is the fixed interest or floating interest. And with the floating interest, when the rate of interest is changed, in the core banking system of a bank also, when the rate of interest changes, the table is also available. From to, that table print also. So simply or blindly, we should not accept the financial creditor also. If at all some financial creditors are charging high, some financial creditors not accepted by you, then the voting rate difference will come. So the claim accepted without scrutiny. altered the composition, voting share of the COC. So, we may not pay 100% to the financial creditor if adequate assets are not available. But the decisions are to be taken based on the voting right. Particularly for voting right, not only all claims are to be properly verified, but double check is very much required in the financial matters. Segregation is also very, very important. Secured and unsecured is also very, very important. Related party is also very important. The claims area is the biggest area with the proofs, available records, and sir? The claim accepted without altered the composition and voting share of the COC. Further, in the same matter, Honorable NCLT also noted that a claim so accepted was barred by limitation. In that case, if at all the claim is there, okay, the claim is a time barred. Why you have admitted? Why you have admitted? Even creditors, the company has accepted the bill of exchange 3 years back, 4 years back, but after 3 years, the bill of exchange is not valid unless there is a acknowledgement of debt. That is to be discarded. So, further, in the same matter, Honorable NCLT also noted that the claim so accepted was barred by limitation and criticized the reliance made by the IP on unreliable documents. So here, the number of case studies are to be built up. So different situations, different claims are submitted, whether to accept or not to accept, and if accept, how much accept, if at all you reject, under what grounds, that is also the lot of expertise is required for the IPS. IP submitted the due process of law followed and the verification was made on the basis of document provided by him. Further asserted, directors of CD did not dispute. Once it is a related party to the directors, if you are paying a higher amount, directors don't dispute. Why that argument is wrong. The RP argument is wrong to the DC, disciplinary committee. No, sir. Whatever the claims I have admitted, corporate data is not pointed out. He is also agreed, means that is not correct. Suppose you take, for example, one claim is admitted instead of 2 crores, 20 crores, and the particular claimant belongs to corporate data of a related party. Definitely, he won't raise that query. And CD did not dispute the debt claim. Also, his attempts to obtain legal opinions was rejected by the COC. First of all,
लेकिन मैं उनसे कहूंगा पथरी निकाल दो
first of all, the RP has to be satisfied with the available records, with the available proof. The DC,
ये तो माइनस में है किसी के लिए
राजेश सिन्हा, राजेश जी अपने म्यूट कर लीजिए. राजेश जी
इसमें
म्यूट है सर.
Okay.
जाते रोटी में लाना पड़ता है.
So the DC also acknowledged NCLT findings reliance upon made an unreliable document. Whatever the documents is given, sir, that is the claim, correct claim, sir, this is the document, that is the document, whether it is a required document or not, that is to be verified. the claims is one of the important area in the CIRP process. Whatever the particular stale or time board debts are there, remove from the particular claims. And if at all proofs are not submitted, please send a letter to them also. So letter to them and ask them to submit the proof. Next one is DC. Okay. Penalties. Dispose the show cause notice with warning. More careful and vigilant while handling the assignment. Learning lessons. The DC conclude that the IP handling financial creditor claims during CIP demonstrated lack of due diligence and objectivity. While he combined with a certain procedural requirement, his failure to critically assess the authenticity of the document undermine the integrity of the insolvency process. So like that, so many cases are there. The Institute of Chartered Accountants of India, IIP, they are also brought one booklet, disciplinary cases initiated by the IBBI disciplinary committee. And not only that one, but ICSI, all people. Here, they, in that particular books also, they have clearly mentioned the name of the resolution professional and the case, all these things they have mentioned. But here, the conclusion is number of disciplinary actions are growth rate is increasing. Growth rate is increasing. Year on year basis, growth rate is increasing. So it denotes proper implementation of regulations or code is not implemented by the RPs or IRPs or liquidators. Or some people, they will take it as a lenience or lightly. Thereby, it affects the imageries as well as penalties, etc. To avoid that one, the disciplinary actions, every month, whatever it is uploaded in the IBBI website, download that one, go through that one, hardly it 2 or 3 pages, not 20 or 30 pages. And then it gives some good results in day-to-day of your profession or while handling the proposals of the CIRP or liquidation. This is compulsory. Otherwise, whatever the efforts we have made to complete the examination, whatever the efforts we are made for a continuous education program by paying the money as well as the time also, there is no use at all unless it is implemented in the assignments. Once the assignments are implemented properly and quality is improved, definitely the financial creditors who are going to give the assignments, always they will also from time to time evaluate the performance of the RP. One example I am quoting here. Earlier I am in State Bank of India. Even advocates also, and quarterly basis or half-yearly basis, we will do the evaluation process. How many cases are given and how many cases are disposed by the advocate and different reports. And once the disposal rate is more, then we are giving a little bit higher when compared to others number of cases. So here also, like CA, the IBC cases also, the indirectly, they are not revealing directly about this one. Indirectly, once the disposal rate is more, without any errors, no errors, or stakeholders are satisfied, definitely the image of the resolution professionals will increase. So this is in brief about today's discussion, sir. And
one question, sir.
Tell me, sir.
Sir, it is good IBBI is punishing errant IPs. But is there any system to award the diligent IPs or recognize? Okay, reward may not be there. Recognize diligent IPs. That will also be helpful to the profession.
Correct. I too agree. Take for example, in State Bank of India also, we are giving ratings to the branch. A plus, A, B, like that. So A rating person now we will send to abroad also with a family. Later on, what was happened in that particular branch, big fraud was happened.
So it varies from time to time.
Yeah.
It depends.
Even irregularities also.
IP was very good in 2022, sir. In 25, he was given show cause notice. He changed.
Yeah, probably because they accept too many assignments and there's too much of work pressure.
Whatever the cases handled by the TC, only certain cases, remaining cases also, if at all we are deeply investigated some mistakes, that is not in limelight. These are in limelight only. That's why these problems are arise.
But there is no such system, sir, awarding diligent.
Awarding, no. So far, no, sir. So far, no.
At least I think they should do something like at least the income tax department, they publish the names of people who are paying diligent taxpayer like that or some at least acknowledgement is there. There is no award. Okay, fine. At least acknowledgement. Probably that might help the.
That is also required. To motivate the resolution profession. To motivate the resolution.
Say somebody has completed 30 large assignments very, very efficiently. Then at least some kind of certificate or something like that.
Correct. Some appreciation letter.
Appreciation, whatever.
From the chairman of IBBI. If that is
like they are putting all the DC orders like that, at least a list of diligent IPs or something like that.
But one thing, sir, one thing, wherever they are conducting audits, ratings are to be given. Ratings.
Okay.
Suppose take for example, in the random audit, your name has come. And they have to give 100 marks for the CIRP or liquidation, whatever the assignments are there. So once you followed all these things, 100 out of 100, even banks also, branches audit ratings are there. So once you got the rating, definitely it is a showcase for you to disclose or to display to the finance secretary. I got the A rating in my audit also, sir. Why can't you give good number of cases like that? That wasted means are there, but now it is evolving.
Probably in future it may come.
Yes.
Okay,
sir. Tomorrow we will meet again. The last
class. Thank you for the excellent presentation.
Okay, sir. Thank you, sir.
Okay.
Thank you.
Your mobile number, sir, can you share?
96184.
1 minute, sir.
39.
It's 96.
184.
Yes, sir.
39.
Yes.
123.
Email mail address?
CMA dot PSR Prasad.
PSR.
P for Patna, S for Secunderabad, R for Ranchi. Prasad, PRASAD at gmail.com.
All
Can
is
you
all
repeat your
letters, sir.
email ID, sir, please?
Sir?
Can
All
you repeat your
what is
email
small,
ID, sir?
small letters.
Yeah, I will put it in a chat box.
Chat box. Please put it
Yeah.
in.
You have put, sir?
Okay, sir. Good
Okay,
night
sir.
to all.
Thank you, sir. Thank you very much.
Okay.
Thank you very much, sir.
Yes, sir.
Okay, madam.
So,
Okay, sir.
thank you. Thank you.